On the morning of July 14th, an equipment operator, Henry Hapgood, was injured. Friends visiting him in the hospital told him that with his injuries, he should have a lot coming to him. They told him to get himself a lawyer. On TV, Hapgood saw an ad for Giles Gordon, a personal injury specialist. After his release from the hospital, Hapgood and his wife Susan met the lawyer in his office.
Henry, I want you and your wife to know, first of all, we like your case, which means we believe we can win in court or settle out big. This is a classic case of everyday people getting steamrolled by a big company. I know, Susan, they offered you some money, peanuts. May look like a lot to you, but to them, peanuts. You want to settle for peanuts? No, why should you? So, Henry, now that you're back on your feet, so to speak, let's get our own steamroller going. I want to go over what you said in your accident report and reconstruct how the events you describe here account for each of your injuries.
You're the boss.
You were operating a motor-driven roller to level the dirt between the footings, prepping to lay bar and pour the floor. Now, this is a big roller, right? Operator walks behind it, controls it by 2 clutch levers on the handle.
Like a lawnmower.
Not like a lawnmower. This is a 1-ton machine that goes forward or reverse at full power. So hard to control, it's a disaster waiting to happen. Remember that. Are you trained to use this machine?
You just turn the key, put it in forward, and hang on, like a lawnmower.
No training. Let's see. You said, I fired it up and pushed the lever to what I thought was forward, turned out to be reverse. The thing backed up in my direction and I pushed against it to try to stop it.
That accounts for the fractured thumbs.
Fractured thumbs. I swung the handle over to the other side, so now it's rolling away from me towards where it punched through the block wall.
Cement blocks, you know? Blocks falling all over. That's how the right foot got mashed.
Fracture right metatarsal bone. I pushed the lever to what I thought was stop, turned out to be forward, and since I was in front of it now, forward meant towards me again, so I jumped clear.
Almost jumped clear. That's what happened to the left leg.
Left femur compound fracture. I couldn't stand up, so I rolled face down into a trench and the machine passed over my backside. That would be the broken coccyx?
Busted my butt. What the boss was always yelling at you to do.
Broken coccyx. By now, the other guys were chasing it. All I could see was dirt. So I put my head up out of the trench to see where it was going next. And I could hear the thing, but I didn't see it. So I turned my head, and then I did see it coming back again.
And see, that accounts for the broken nose, the teeth, and a concussion.
Henry, you are lucky to be alive.
Don't look so lucky.
We're going to make a video of just how you look. If a jury gets a look at that, and we get 7, 8 figures from the manufacturer, that's millions. You will count yourself very lucky to be alive. Now, to get that, we have to go after punitive damages. We need to tell that jury, the evidence shows that a reckless, negligent, billion-dollar corporation handed this worker a machine so dangerous, so defective, it was a catastrophe waiting to roll over him. As soon as we file, we'll get into discovery, document search and seizure, interrogatories, and depositions. We'll depose everyone right down to the mailroom, and you'll be amazed at what we'll get them to say. The defendant's people will build your case with their own words.
Cal, this is Alan Anderson in legal. You're going to be deposed in the Hapgood case. Could we meet sometime today? Don, before you're deposed, we'd like to show you what to expect. Alan, you're scheduled to be deposed next week. Do you have an hour? Beverly, you're on the list of deponents. Have you ever testified? Enrique, you're going to be deposed. Can you come in for an hour or so we can talk?
A lawsuit, or criminal case, leads off with a legal process called discovery. Opposing lawyers in a civil dispute, or prosecutors and defense lawyers in a criminal investigation, are authorized by the court to discover evidence to support their sides of the case. Depositions are part of that process. In this case, discovery began with a request for documents. Lawyers retrieved all relevant documents from the company's paper and electronic files and turned them over to the plaintiff's lawyer. In turn, the company's defense team requested documents from the plaintiff, his employer, supervisor, eyewitnesses, emergency responders, and others. Interrogatories required people on both sides to give written answers to questions. Depositions were a critical part of discovery. Company lawyer Al Anderson and lead defense lawyer Elizabeth Bowers met with people on the list of deponents to prepare them to testify, starting with Calvin Kramer, engineering group manager.
Great. Why don't you please have a seat?
The injured worker, Hapgood, how's he doing?
The plaintiff? He's in tough shape, going to need a lot of rehab. But his treatment is amply covered. We've offered a cash settlement to compensate him and help put his life back together. A substantial amount.
But they want to go for tens of millions, punitive damages. That's why they're looking to find evidence of gross and wanton negligence on the part of your company.
They're probably going to claim that when Hapgood dropped that handle, the dead man bar failed to kill the engine because of defective design and manufacture.
I don't buy that. Do we know what really happened?
We found evidence that the dead man lever had been taped to the handle to prevent shutting off the engine, probably for the convenience of the operator. And someone removed the tape after the accident.
We will show the accident was caused by a disabled safety device, by poor training and incompetent operation. We don't want to hand them anything in depositions to help them make a weak case look like a strong one.
So what happens at a deposition?
You'll be in a conference room. A lawyer will be there representing the plaintiff, and Liz will be there representing us. Could be other lawyers there, too. Stenographer will be in the room taking everything down on a Cenotype machine or a tape recorder. Or the deposition might be videotaped.
Days or even weeks later, you'll review a typed transcript. You can make changes if you have to. The fewer the better. Then you'll sign off on it, and it becomes your sworn testimony.
Now, what was that about video?
We'll let you know if it's going to happen. If your deposition were to be videotaped, the same basic rules would apply. The main thing would still be what you say in your testimony.
But of course, how you say it becomes more important on video. If your deposition is going to be videotaped, we'll get together again for a practice session with the camera.
Right. Now Liz is going to role play the opposition lawyer doing some Q&A.
This is like a foreign language to me, you know?
I do know. But there are 8 basic rules that will take the mystery out of it. Tell the truth. Stay on guard. Think before you speak. Stick to what you know. Just answer the question. Speak for yourself. Read documents before you respond. Keep your cool. Rule number 1, tell the truth. First, you'll be sworn in by the stenographer, saying something like, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
From this point on, everything you say is on the record, under oath. You'll be asked to state your name, your place of employment, your job title, so forth.
You can truthfully answer most questions with one of 5 simple answers. Yes, or no, or I don't know, or I can't recall, or I don't understand the question. Most are yes or no questions. Mr. Kramer, did you discuss this deposition with your counsel?
Yes.
Did you discuss questions you might be asked?
Yes.
Did you discuss how you might answer certain questions?
Yes.
Did counsel give you advice as to your answers?
Yes. Is it okay to say that?
It's the truth.
But doesn't that sound like I was coached?
No, just advised. You have a legal right to be advised by counsel on anything related to your testimony. Not by anyone else, however. A conversation with counsel is protected from disclosure by attorney-client privilege, which is one reason you discuss these matters only with us.
Were files related to this case destroyed anywhere in your department?
No. No way.
So we can rely on statements that all relevant documents were retained.
Yes, absolutely all.
There was no shredding or erasing of any potential evidence.
No, never.
How about smoking guns? There was never a suggestion to get rid of smoking guns in email files?
I don't really recall anything like that.
We have...
Wait a minute. Cal, you started off sounding totally certain. You used words like no way, absolutely all, never. Now you sound hesitant. You really don't recall.
That's something I need to talk to you about. Over a year ago, there was a big debate in the engineering group about the new roller. Email was going back and forth, getting hotter and hotter. After the design was finalized, before any accident happened or any lawsuit, I sent around word that people should delete or shred
any smoking guns.
Like we had one engineer, tested the prototype, thought it was great. So he emails the entire group, called it a killer machine. Killer as in excellent, great, cool. Anyhow, I told them to get rid of words like killer machine in the files.
Shows how important it is for people to be careful what they write in the first place.
Especially email. In discovery, email files are a gold mine. The first thing they look at. Deleting an email message can come back to haunt you.
But testifying in your deposition that you can't recall when you can would really come back to haunt you.
Like all your other answers, I can't recall is testimony, under oath. When you say, I can't recall, that has to be the truth.
Suppose your deposition is finished. You've signed off on the transcript, haven't changed a word. Let's jump ahead a few months. You're on the stand in front of a jury. Show Cal how the questioning could go.
Mr. Kramer, this email message, Exhibit 293, addressed to all members of the design group, would you read that to the jury?
Dudes, we have built one killer machine. Where did you get this?
Mr. Kramer, that message was recovered from system backup files, but it's been deleted from the hard drives of everyone who received it. How might that have happened, if you know?
I don't know.
Don't know. Do you recognize this message? Exhibit 294.
Looks like an email from me addressed to the group.
Would you read the highlighted portion?
We should scan our files for anything that could become a smoking gun and dump it to trash. I was kidding when I wrote smoking gun.
Now would you read your email message, Exhibit 295, addressed to all sent after this lawsuit was filed?
Forget my suggestion about smoking guns. We have to save everything until this case blows over.
Blows over. And finally, this message, Exhibit 296, sent to you from one engineer.
Too late, Cal. I just fed her to the shredder. CL, there are a few things we need to talk about.
We sure do. But for the moment, you're still on the stand and she's not through with this.
Mr. Kramer, let me read to you from the transcript of your deposition. Question: there was never a suggestion to get rid of smoking guns in email files. Answer: I don't really recall anything like that. Did you answer truthfully in your deposition?
Yes. I didn't recall at that time.
Did you subsequently begin to recall?
Yes.
Did you amend the transcript by adding what you subsequently recalled?
No, I guess not.
So you allowed the transcript of your deposition under oath to stand with an untruthful answer?
Yes. I guess I thought...
That's all, Mr. Kramer.
In the eyes of the jury, it would sound as if you destroyed evidence, instructed others to destroy evidence, and testified untruthfully in your deposition. And that would cast doubt on your entire testimony.
Cal, you have to give us any bad news up front. That way we know ahead of time what we have to deal with.
So that's it for point number one. Just tell the simple truth. The simpler, the better. Yes, no, I don't know, I can't recall, I don't understand the question. Let's move on to point number two, stay on guard.
This isn't going to be as hard to take as I thought. Just tell the truth.
Good, that's rule number one. The second point we want to make, Don, is stay on guard, like a sentry watching for an enemy sneak attack.
Ugh, this is a new application. I'm having so much trouble getting used to it.
They're always changing how your applications work.
Makes you crazy, doesn't it? I'm supposed to be able to enter a word or phrase, and it will search and display everything with that word or phrase highlighted.
Are the files linked?
I guess. Say I typed in the words killer machine. You know, the phrase that was deleted from all your files?
Not in our department. That was Cal Kramer's group.
Right. This is just to show you what my problem... Oh, there it is. I must have done something right. And you were right. It was Kramer's people who deleted anything that looked like bad news. Just trying to make themselves look better, you think?
Sure. Cal's always griping they're under pressure to keep their safety record clean.
Well, you can see why they wouldn't want stuff like killer machine in their files, especially if they were under... You said they were being pressured to make their records look good?
I don't really know. Are we... Is that a question?
Question or not, everything you've been saying is testimony.
How did we get onto that track?
I led you onto it. Chatting about computers. Got you to let down your guard.
A lawyer may come on all casual and friendly, chat about work or sports, crack jokes. You start thinking, she's got a great sense of humor, or he's a guy just like me. You begin to feel you can relax. Don't. Stay tense. This is not small talk. This is an examination by an adversary. Everything is planned. No remark is off the cuff. No response is off the record.
Keep yourself on edge. Sit forward, feet on the floor, all business. Through the entire interrogation. Stay alert, stay focused, stay on guard. Ellen, I want to go back to that data that turned up missing, as they say. Is it true that in your department, were you under the impression that...
No, we never were.
Were what?
Under pressure to sanitize our files. Purge hazard reports? Isn't that what you were about to ask?
No, it wasn't. But since you bring it up, wasn't that because reporting product hazards was handled by Kramer's department, not yours?
That's right.
Accident reports, did they...
Yes. All reports of product accidents. They handled those.
So if an accident report is missing from their files, it was probably removed. Is that...
Or you haven't looked hard enough.
Exactly. It's either one or the other. Either the data is there and we, or they, haven't found it, or the data was there and at some point it was removed. Is that what you're saying?
No, I don't want to say that.
Ellen, are you aware of how you're rushing your answers? Sometimes you jump in before I finish my question.
Oh, sorry. I rush everything. Everybody says, slow down, Ellen.
Well, I'm going to say it too. Slow down. Listen to the entire question. Replay the question in your mind. Think out your simplest, truthful answer, then respond.
Before you respond, ask yourself, do I understand the question? Do I know anything about this topic? Can I personally recall the action, conversation, document called for? Can I simply answer yes or no?
Won't those pauses look as though I'm stalling or hiding something?
Not on paper. The purpose of most depositions is to produce a written transcript. On a typewritten page, pauses, short or long, look the same as immediate answers.
If your deposition were going to be videotaped, my advice on this point would be a little different. You'd still want to take time to think, but on video, extra long pauses can look as if you're stalling or concocting a story.
If this were going to be taped, we'd give you practice answering the questions on camera. There's another reason to pause before you answer. Suppose the line of questioning went like this. Ellen, were you aware of any company legal problem last year?
Yes.
During discovery for an antitrust suit against the company last year, was there pressure from anywhere to destroy email files?
I object. That question is too broad to answer. Now, if I object, stop what you're about to say and listen to the objection. I might be alerting you to a problem with the question.
So that's the other reason for pausing before you answer. It gives you time to think and gives your attorney time to object to the question.
What all this comes down to is think before you speak. Ellen, a deposition examines your recollection of the facts, so stick to what you know.
In the old TV show Dragnet, Sergeant Joe Friday was always saying, just the facts, ma'am. That's what you want to give to the examiner, just the facts as you know them. If you don't know, if you can't recall, if you don't understand the question, say so.
Was there a need to remove certain features from the design that might infringe on patents held by a competitor?
I don't know.
Weren't you at a meeting on August 10th to discuss patent infringement problems?
No.
You were at that meeting, weren't you?
Yes.
Why were you at that meeting?
I was there as an observer from the marketing department.
But you were there. So how can you say you don't know about features that might infringe patents?
Because I don't know anything about patent laws.
That's right. You're a marketing person, and patent law is outside your area of knowledge. So I don't know is the truth, and you should stick to it.
After that meeting on Monday, didn't redesign work begin that same day?
I couldn't say. I don't know.
Friday that same week, there was a progress report on the redesign. Isn't that true?
Yes.
So isn't it reasonable to assume that design work began between Monday afternoon and close of business Thursday?
Yes, it's reasonable.
So you agree that in all probability, redesign began on Monday?
No, I don't know exactly when it began.
That's fine. You didn't let her turn an assumption or an estimate into a statement of fact. And watch out for phrases like, is it possible, or isn't it probable, or could it be, or isn't it reasonable to assume? Stick to what you know. Now the next point is about volunteering information.
Excuse me, Beverly, do you know what time it is?
Yes, it's 3:30.
Thanks. But what did I ask?
You asked, what time is it?
My question was, do you know what time it is?
Yes.
Yes, you do know what time it is. Truthful and responsive to the question. Let the questioner follow up to get more information. So, what time is it?
It's 3:31. Oh, about 3:31. My watch is a little fast. You didn't ask how accurate my watch is.
Right. Don't volunteer something the question doesn't ask for. The question was, what time is it?
About 3:32.
That's the idea. Now, did the advertising campaign have a slogan?
Yes.
And was that slogan easy to operate as a power mower?
As a lawnmower, yes.
In the course of getting the product ready to be put on the market, wasn't the design simplified in order to make good on that advertising slogan?
No. It was to avoid patent infringement.
No answered the question. Liz didn't say anything about patents.
She didn't say anything. She just stared at me as though I should continue.
The pregnant pause. It's a gimmick. It's a way to get the deponent to fill in the silence. Sometimes volunteer an extra nugget of information. Before that, you corrected me on the slogan.
I guess I was just being helpful, giving you the right word.
Sure, in normal conversation, the courteous thing to do is to contribute something, help the other person out. But this isn't a normal conversation. This is an interrogation by an adversary. Make them formulate their own questions. Don't prompt them, don't rephrase for them, don't help them out.
To finish up this point, have you told us everything?
I don't understand the question.
What don't you understand?
I don't understand what you mean by everything.
Everything you know. Have you told us everything you know?
I still don't understand the question.
Good. That's another examiner's tactic.
The catch-all question. If a question leads to confusion in your mind about the question, the best, the most honest, simplest thing is to say, I don't understand the question.
What our point number 5 adds up to is just answer the question, don't volunteer information. Let's go on to the next point. Point 6 is don't let the examiner put words into your mouth. Speak for yourself.
Wouldn't you say the purpose of the emergency cutoff switch we've been discussing was safety?
Yes, primarily.
So we could call it a safety switch.
Right, yes.
This safety switch was redesigned under the gun, so to speak, August 20th?
Well, I wouldn't say under the gun.
Okay. It was entirely redesigned, and the two features we've been talking about were removed by August 20th. Is that correct?
Yes.
The redesign got the go-ahead the afternoon of August 10th, right after the meeting, right?
Yes.
That makes the redesign period 8 working days. Am I right there?
Yes.
In your experience at this company, was this redesign period longer or shorter than similar redesign efforts?
Shorter, I guess. Shorter than some, longer than others.
How many similar redesign efforts have you observed here?
Maybe a couple of dozen?
And how many of those redesign efforts were given less time than in this instance? Less than a dozen? More than a dozen?
Less than a dozen.
Would it be half a dozen, give or take a few?
About that.
Let's say 6 to 8 out of some 24 designs. So 60 to 70% of these redesign efforts received more time than in this instance. Is my math correct?
I guess that's right. Yes.
So, after the hurry-up order was given, the redesign to strip off safety features that might cause patent infringement problems was pushed through in 8 days, faster than all but a few similar instances, to meet a marketing deadline. Does that sum up what we've been saying?
Yes, basically.
Hang on a minute. Did that correctly summarize what you've testified?
I think so. Well, not word for
What
word,
about the
but...
spin I gave my words? I said the hurry-up order was given. You said go-ahead order. Hurry-up order suggests recklessness, and you agreed. I said the redesign was to strip off safety features. That suggests redesign impaired safety, when actually it improved it. I said the redesign was pushed through in 8 days, which implies a full speed-ahead order. My words, to meet the marketing deadline, suggests that safety standards were pushed aside in order to rush to market.
Don't let the examiner put words in your mouth that distort your testimony. Those words may lead a jury to see our redesign as hurried and negligent in everything except sales goals.
Let me rephrase it. To sum up what you've been saying, after the go-ahead order was given, the redesign to avoid patent problems was accomplished within 8 days to meet the scheduled product intro at the upcoming trade fair. Is that correct?
No, it's not correct.
Now, you rejected that summary.
It was only those words about doing it to meet the scheduled product intro at the trade fair. I didn't say that was why redesign was done in 8 days.
Exactly right. The examiner has offered a series of propositions linked together. If one proposition is incorrect, the whole series is incorrect. Just another attempt to get you to testify to the examiner's characterization of things. You didn't buy it. Good. Speak for yourself. Enrique, point 7 is about how to deal with documents.
Now, Mr. Rodriguez, this printout is the email message your group manager sent after redesign was complete. Is that correct?
Yes. She was congratulating us on doing a great job under pressure.
You received this message in late August?
Just before I went on vacation, yes.
This message was sent to everyone in the group,
Yes.
written by the group manager.
Yes.
Enrique, you just testified that the group manager wrote, "Dudes, we have built one killer machine." In this comment, "We beat them to market. First across the finish line gets the gold, folks."
No. She never wrote that. Could I see it again? No, those words must have been added by someone else and forwarded to all.
Her original message without these added comments was erased, but saved in a backup file.
At first glance, it looked like her message, just the way we all received it.
If an examiner introduces a memo, letter, email, before you answer questions about it, check the letterhead, the date, the time, who it's addressed to, who signed it, who got copies. Same with email. Check the header for date and time, received and sent, who the sender was, distribution list, attachments, and make note of any text that's been inserted from another source. Read the entire document before you respond.
Documents can be tricky. For example, at the Jefferson Memorial in Washington, can you tell me what those inscriptions are, who wrote them, and when?
They're from the Declaration of Independence, written by Thomas Jefferson in 1776. No?
Not exactly. The inscriptions were edited by a committee and by President Roosevelt in 1941. They changed some words, they added some words, left some out. And not all the Declaration was written by Jefferson in the first place. So even when a document is chiseled in stone, so to speak, You can't assume you know what it is, where it came from, and who wrote it.
Better to say it appears to be the document, as far as I can tell. So if I asked, is that your signature?
It appears to be.
You said you got in from Toronto after midnight. Aren't you going to beat?
Yeah, but let's keep going.
We appreciate that. But you know, in your deposition, it might be wiser not to keep going. Depositions can last for hours. And you may find your examiner is saving the toughest questions for last, just when you're running on empty.
So if you find you're getting tired, concentration drifting, don't make yourself keep at it. Ask for a break. Get out of the room, freshen up, pour another cola, get a second wind.
Goes back to what we were saying earlier. Stay on guard from start to finish, especially as we move on to our final point. Testifying at a deposition, at a grand jury, in court is no place to lose your cool.
The plaintiff's counsel might try and get the deponent steamed up, needle you, belittle you, question your integrity.
Anything to get you to see red instead of seeing where he's leading you. But always remember, it's never personal. It always has a purpose to get you to pop off answers without thinking. Liz?
Prior to August 15th, did you erase messages in email files?
Yes.
Were those messages related to this case?
Yes, some of them.
In fact, a number of people in your department were ordered to delete and destroy every word of email that might cause legal trouble. Isn't that right?
No, that's wrong.
Did I hear you right? You said no, they weren't ordered to delete email?
You heard me right.
You persist in stating that the purging of evidence did not take place as I described? You do get what's going on here, Enrique, or do you? You know that you are under oath. You know that if you lie under oath, that's perjury.
Is that a question?
Are you having trouble following this? Of course it's a question. What have we been doing here all this time?
Please repeat the question.
Let me put it to you this way. See if you can follow this. Do you want the record to show that you deny destruction of documents happened the way I described?
Yes. That's exactly what I want the record to show.
You didn't get him, Liz.
I tried.
That's good. You didn't let it get personal, didn't argue, didn't talk back.
And you made me rephrase a loaded question.
Shows how important it is to keep your cool. Before you go, there are a couple of basic points we've been telling everyone about the discovery process. As long as we're in discovery, and it could take months, both sides are required to save everything that pertains to the case. So retain all documents, destroy nothing.
Attorney-client privilege protects communications with your lawyer. If you have any questions or need information about this case, contact Al or me.
If you want me to have something in written form, write attorney-client privilege on the heading and send it to me in a sealed envelope marked confidential.
How about email?
Very simple. Don't use email for anything that should be protected. Email is not confidential or private.
Thanks, Enrique. Looks like we're all set.
Okay. Thank you.
It was determined that Calvin Kramer's deposition would have to be videotaped, because he might not be available. Kramer came back to the legal team for pointers about testifying on camera.
Okay.
Cal, everything we said about depositions applies to answering questions on video, except it's more like testifying in court. Portions of the tape may be shown to the jury, and video magnifies every twitch and blink. We'll tape some Q&A, and you can decide for yourself if there are things you need to work on. Go ahead.
All set.
This is the deposition of Calvin V. Kramer, Engineering Group Manager. Place, date, time, administer the oath, etc. Mr. Kramer, the redesign of the safety switch got the go-ahead the afternoon of August 10th. Is that correct?
Yes.
In your experience at this company, was the redesign period of 8...
Before we replay the tape, how do you feel you made out?
Thought I did okay. Told the truth, didn't rush my answers, stayed calm.
True. Your responses would look fine on paper. But Take a look what a jury might see in a video screen.
Mr. Kramer, the redesign of the safety switch got the go-ahead the afternoon of August 10th. Is that correct?
Yes.
In your experience at this company, was the redesign period of 8 working days in this instance longer or shorter than similar redesign efforts?
I don't really know. I thought it was normal.
How often did you observe similar redesign efforts that took less time than this?
I really couldn't say.
Could you take a guess?
My guess would be off by 100%.
Could we say a number of similar redesign efforts were given more time than in this instance?
Could be.
So, would you say that to be ready for the upcoming trade expo, the redesign of safety features was pushed through in less time than a number of similar instances?
Could we pause the tape for a minute? Is that the way I really look? My eyes were going all over the place, like I wasn't telling the truth. And it's taking me forever to answer, like I'm hiding something.
Video or not, the crucial thing is what you testify. But on video, how you come off means a lot. You want to look businesslike, starting with your wardrobe. Sit up, sit still, speak up. You want your demeanor to appear confident, sincere, and always polite. Timing your responses affects their credibility. Don't pause too long before you respond. And it's very important what you do with your eyes. If you let them wander around, you look shifty, dishonest. Make eye contact with something. While you're listening, focus your eyes on the person asking the question. While you're thinking, pick one spot behind the questioner and focus on that. When you're answering, focus on the questioner or focus directly on the camera.
A few days later, Cal Kramer was videotaped at company offices as he was deposed by plaintiff's lawyer, Giles Gordon.
In your experience at this company, was the redesign period of 8 working days in this instance longer or shorter than similar redesign efforts?
I really don't know. It seemed normal.
How often did you observe similar redesign efforts that took less time than this?
I couldn't say for sure.
Could you take a guess?
No, I just don't know.
Could we say a number of similar redesign efforts were given more time than in this instance?
Could be.
So, would you say that to be ready for the upcoming trade expo, the redesign of safety features was pushed through in less time than a number of similar instances?
No, I would not say that.
Kramer made good use of the 8 guideline points. His confident appearance reinforced his credibility, and his testimony on tape was highly effective.
But the truth to help you guys.
I do.
On November 5th, in the offices of Giles D. Gordon and Associates, the depositions started. They lasted over 2 weeks. 17 deponents from the company were called. They were accompanied by Elizabeth Bowers, the defense lawyer. Other lawyers attended, representing the contractor, insurer, and developer. The proceedings were recorded by a court stenographer.
Ms. Frank, did company lawyers advise you how to answer today?
Yes,
What did they advise?
to tell the truth.
Hour after hour, deponent after deponent told the truth.
Just between you and me, don't you think that it was a short turnaround time for a redesign? I mean, I've had a car repair take longer. You know what I mean?
No, I don't. Could you clarify that?
They stayed on guard, never confused the examination for a casual chat.
Mr. Rodriguez, how many email messages were deleted after the order came from Kramer?
I don't know.
They took time to think before each answer.
Mr. Rodriguez, is there anything else, anything at all that you can tell me about this?
No.
They just answered the questions as posed to them, and didn't volunteer information not asked for.
If they had taken longer to test the redesigned unit, would they have missed the new product kickoff, which was scheduled for the spring trade show?
I don't know anything about that.
They stuck to what they knew and were careful not to guess or speculate.
Miss Edwards, they took shortcuts on safety. Isn't that what you're saying?
No, that's not what I said.
In each answer, they spoke for themselves. They never allowed the examiner to put words in their mouths.
Mr. Duquesne, could you please identify this document for us, sir?
It'll take me a few minutes to read this.
When presented with documents and questioned about their contents, they read thoroughly before responding.
What kind of engineering idiot would allow something like that to be put on the market? You people are pathetic.
I don't understand the question.
And no matter how the examiner treated them, they kept their cool. 2 weeks later, the depositions ended. Throughout the months of discovery, the plaintiff's lawyers had found nothing substantial on which to build a case for negligence. The depositions were the last straw.
We cannot put those people in front of a jury.
A few weeks later, before trial, the suit was settled for about what the company had offered in the first place.